I didn't want.
One and my fifty.
Part SPV, the United Senior Counsel Additional Public Prosecutor, assisted by Miss Ardas, Leonard, Counsel for the Respondent State. This criminal appeal from jail is against a judgment dated 28/6/2024, passed by the Court of Learned Additional Session Judge, Crown Special Judge within bracket POXO, Sipsagar, in special bracket POXO, case number 55 of 2023, which arose out of the Mo Police Station case number 32 of 2023. Also, by the judgment in order dated 28/6/2024, the accused appellant has been held guilty for the offenses under section 376 within bracket 3, Indian Penal Code, and section 4 within bracket 2, protection of children from sexual offences Act 2004, in view of section 42 POXO Act, the accused appellant has been sentenced to undergo rigorous imprisonment for a period of 20 years and to pay a fine of rupees 10,000, in default of payment of fine, to undergo rigorous imprisonment for another 6 months. The criminal appeal is admitted for hearing. Issue notice returnable in 4 weeks as MS. That additional public procedures appeared and accepted notice on behalf of the respondent number 1, State of Assam. Issuance of formal notice. This respondent number 1 is dismissed with their office to issue a notice for service upon the respondent number 2 that's informant, to informant, to the informant, who is to be treated as respondent number 2 in this criminal appeal, and to for a service report from the officer in charge, Mo Police Station, by the returnable date. To stop. After issue of the admit for hearing, case records also case number so and so we call for this in order to represent the accused appellant, who is Vikas Prasad, which limit proper to come in the interest of justice to appoint Mr. Vikas Prasad, learned counsel from the panel of amicus curiae. First of the office to inform Mr. Vikas Prasad, learned counsel, according. Please the case out of courts. This notice is to be by the office to the officer of public prosecutor. Okay. Office to prepare a notice for the informant of the Mo Police Station case number so and so is implemented as respondent number 2 in this appeal. The office to prepare a notice for service upon the respondent number 2 as informant, and to and thereafter, to serve the same and thereafter to uh, submit the same to the office of the public prosecutor, Guwahati High Court. Post of the office, the learned public prosecutor, in turn, has to serve the said notice upon the respondent number 2-informant to the officer in charge, Timor Police Station, and to place a copy of the service report before this court on the returnable. Hardness be learned senior counsel, and additional public prosecutor for the respondent state. We should be good argument, but this criminal appeal from jail is against a judgment in order dated 23/5/2025, passed by the Court of Learned Additional Session Judge, Vishwanath Sarili, in Sessions Case number 280 of 2023, by the judgment and order dated 23/5/2025, the trial court has convicted the accused appellant for the offences under Section 302 IPC and Section 201 IPC. For the offence under Section 302 IPC, the accused appellant has been sentenced to undergo rigorous imprisonment for life and to pay a fine of ₹5,000, with default stipulation. For the offence under Section 201, the accused appellant has been sentenced to undergo rigorous imprisonment for 2 years and to pay a fine of ₹2,000, with default stipulation. Both the sentences are ordered to run concurrently. We have heard Ms. P. Bhuyan, Senior Counsel and Additional Public Prosecutor for the respondent's team. Also, the criminal appeal admitted for hearing the case records of Sessions Case number 280 of 2023 be called for. Issue notice returnable in 4 weeks, as MS Priya, the Additional Public Prosecutor, has appeared and accepted notice on behalf of the respondent state, issuance of formal notice to the respondent state is dispensed with. Poster. 301. In order to represent the accused appellant in instant criminal appeal, we deem it proper, in the interest of justice, to appoint Sri Devanga Kumar Baito, an advocate from the panel of amicus curiae, to office to inform Sri Devanga Kumar Baito and counsel and amicus curiae accordingly. Please take it out of police. Item 3. Already appointed, I think. Will issue notice letter. Will admit the appeal on this criminal appeal under Section 4152 of the Bharatiya Nagarik Surakha Adhikar 2023 is directed against a judgment, an order dated 25/11/2022, passed by The Court of Language Specialist POCSO case here. In POCSO case number 25 of 2024, which arose out of Bordubi Police Station case number 158 of 2023. Sorry. To stop by the judgment, an order dated 25/11/2024, the accused appellant has been found guilty of the offenses under section 4(2) Protection of Children from Sexual Offences, POCSO Act 2012, and section 376(3) of the Indian Penal Code, also in view of section 42 of the POCSO Act. 42. The accused appellant has been sentenced to undergo rigorous imprisonment for 20 years and to pay a fine of rupees 20,000, with default stipulation under section 4(2) of the POCSO Act. Full stop. We have gone through the statements and averments made in the memo of the bill. The criminal bill is admitted for hearing. Issue notice returnable in 4 weeks. As MS Mia, Land Traditional Public Prosecutor, has appeared and accepted notice on behalf of the respondent number 1, State of Assam. Issuance of formal notice to respondent number 1 is dispensed with. You need any extra copy? The accused appellant shall take steps for service of notice upon the respondent number 2 as informant by it is in terms of the practice direction. So and so within 3 working days from today. The additional public prosecutor is to obtain a report as regards service of notice upon the respondent number 2 as informant from the officer in charge, Bordubi Police Station, and to place the same on the returnable date. Place the case of the 4 weeks. The name of Miss Anne Hassan, learned legal aid counsel for the accused appellant, is to be depicted in the cause list. Acquittal.
Yes. Feel against submission.
Hard, Mr. Yes, Miss Hard. It is proviso to 413.
430 proviso 2. Proviso.
Hard, Mr. B.M. Chudru, learned counsel for the appellant, and Miss M. Mia, learned senior counsel in additional public prosecutor for the respondent number 3, State of Assam. So the instance. So it is a statutory right nowadays.
Now it is statutory.
This criminal appeal under the proviso to section 413 of the Bharatiya Nagarik Surakha Samhita 2023 is preferred against a judgment dated 29/3/2025 passed by the Court of Language Additional Section Judge FT60 Bhumi Trial Court in sessions case number 122 of 2014. First of, in the trial of sessions case number 122 of 2014, two charge-sheeted accused persons, arrayed herein as the respondent number 2 and the respondent, respondent number 1 and the respondent number 2, had faced charges for the offenses under section 302 IPC and section 201 IPC. Close stop. On conclusion of a trial, the learned trial court had acquitted the two said to suspected accused persons from the charges of 302, Redwit 302 and section 201 IPC, Redwit section 34 IPC. They acquitted the accused persons from the charges under section 302 stroke 201 stroke 34 IPC. Post stop. Agreed thereby and dissatisfied with the impugned judgments dated so and so, the present bill has been preferred. So we have gone through the statements and environments which in the memo of bill, the criminal appeal is admitted for hearing. The case records of Sessions case number 122 of 2014 call for issue notice returnable in 4 weeks as MS Mia, an additional public prosecutor, has appeared and accepted notice on behalf of the respondent number 3, State of Assam. Issuance of formal notice to the respondent number 3 is to Spendrich. Also, extra copy within 3 working days. The appellant shall take steps for service of notice upon the respondent number 2 and the respondent number 3 by registered post with AD within 3
1 and 2.
one and one by registered post to AD within 3 working days from the date. This is the case of the police. Hard. Yes. Hard. Miss B. Torma. Learned legal counsel. A legal counsel for the applicant appellant. And Miss B. Learned senior counsel and additional public prosecutor assisted by Ms. Ardas Learned counsel for the opposite party number 1. State of Assam. Post by instant application under section 5 of the Limitation Act 1963 is prepared seeking condonation of delay of 258 days, which have occurred in filing the accompanying criminal appeal from criminal appeal against a judgment and order dated for 8/8.
2 dates, one, but the sentence part is of 14.
Which page? Sentence. In a memo, Pipi.
The judgment of
Okay. Against a judgment dated 8/8/2024 and an order on sentence dated 14/8/2024. Posted by the judgment and the order on sentence. The accused, the applicant appellant has been they have occurred in preferring the accompanying criminal appeal. The applicant as the appellant has preferred the accompanying appeal against a judgment dated 8/8/2024 and an order on sentence dated 14/8/2024 passed by the Court of Learned Session Judge Baksa at Mosulpur in Sessions case number 199 of 2018, exposed by the judgment and the order on sentence, the applicant appellant has been convicted for the offense under section 302, Indian Penal Code, and he has been sentenced to undergo rigorous has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 2,000, in default of payment of fine, to undergo simple imprisonment for another. We have gone through the statements and amendments made in this application, more particularly, paragraph 4. Also, having gone through the statements and amendments made in the instant application, we are of the considered view that the applicant appellant has been able to explain the period of delay of 258 days, showing sufficient cause. Most of the applicant appellant has been sentenced on 14/8/2024. Post of the Superintendent District Jail, Nalbari, had forwarded the matter to the Jurisdictional District Legal Services Authority only on 6/5/2024 for preparing an appeal. Post of. Thereafter, the jurisdictional DLSA at Baksa forwarded the case of the applicant appellant to the Guwahati High Court Legal Services Authority on 14/5/2025. Post of. In the process and post of. And it was only on 9/6/2025, the learned legal aid council has been requested to prefer an appeal. Post of. In the process, the period of delay of 258 days had occurred. Post of. Moreover, we are also, we are also to consider view that since the applicant appellant has been sentenced to undergo imprisonment for life, interest of justice will be better served if the accompanying criminal appeal is heard on merits after considering the period of delay, which appeared to have occurred without any fault on the part of not much on the fault on the part of the applicant appellant. So, as we are an additional public prosecutor has barely submitted that since the period of since the applicant appellant has been sentenced to undergo life imprisonment, the state has no objection if the accompanying criminal appeal is hard on merits. Also, in view of the above discussion, instant application is allowed para the registry to register the accompanying criminal appeal and thereafter to place the same for admission. Item 6. Heard Miss B. Hazorik. Yes. Offense. Also. Learned counsel for the applicant, the appellant. And Miss B. Fuyan, learned senior counsel and additional public prosecutor for the opposite party. Number 1, State of Assam. Also. The instant application under Section 5 of the Limitation Act 1963 is prepared, seeking condonation of delay of 9 days, which has occurred which has occurred in filing the accompanying criminal appeal post of wherein the applicant as the appellant has preferred the accompanying criminal appeal under section 415 2 Bharatiya Nagaric Suraksha Manita 2023 against the judgment and order dated 2/4/2025 passed by the Court of Law and its Special Judge Bongaigaon in special within bracket P case number 01 within bracket BGN bracket close of 2024, which arose out of Bongaigaon Police Station case number 399 of 2023. By the judgment and order dated 2/4/2025, the applicant appellant has been convicted for the offenses under section 376 within bracket AB, IPC rate with section 506 IPC. Rate with section 6, POXO Act, in view of section 42 of the POXO Act, the applicant has been sentenced only under section 6, POXO Act. For the offense under section 6 POXO Act, the applicant appellant has been sentenced to undergo rigorous imprisonment for 20 years and to pay a fine of rupees 10,000 for the offense under section 506 IPC. The applicant appellant has been sentenced to undergo simple imprisonment for 1 year. Both the sentences are ordered on there in ordered to run concurrently. We have gone through the statements and environments made in the application more particularly. Paragraph 2 thereof. Having gone through the statements and environments made in the application, we are of the considered view that the applicant has been able to explain the circumstances showing sufficient cause for which the delay of 9 days had occurred in preparing the accompanying criminal appeal. We are also of the considered view that since the applicant has been sentenced for a period of 20 years, interest of justice will be better observed if the accompanying criminal appeal is hard merits after continuing the period of delay, which is not significant. Ms. Priya and additional public prosecutor has barely submitted that since the period of sentence is 20 years, the accompanying criminal appeal is to be heard on merits after serving due notice upon the opposite party number 2 as informant. We deem it proper, in the interest of justice and for expeditious consideration of the accompanying criminal appeal, to dispense with the notice to the opposite party number 2 as informant at this stage. the opposite party, number two, that's informant, has been implicated in the accompanying criminal appeal as respondent number two. First of, as the accompanying criminal appeal would be heard on merits only after effecting due service upon the respondent number two, comma, the notice to the opposite party number two, that's the opposite party does respond number two at this stage is not necessary and hence has been dispensed with. The office to the registry to register the, hence the instant, the application stands allowed. Office to the registry to register the company criminal bill and to therefore release the same for admission.
Your Lordship, it's Bongaigaon Station case number 399 of 2023.
Not required. We are dispensing with.
Seven.
Thank you, Mr. Lordship. Connected criminal is against conviction number section 302 IPC and today is for combination of criminal Lordship,
Yes, ma'am.
85 days.
Hard. Miss and Hassan. Learned counsel for the applicant appellant. And Miss P. Mia, learned senior counsel. And additional public prosecutor. For the opposite party number one, comma statements. First of the working section 5 beginning 85 days. Where the applicant as the appellant has preferred the accompanying criminal appeal under section 4152 Bharatiya Nagaric Surakha Audit 2023 to SLA judgments dated 22/1/2025 and an order on sentence dated 30/01/2025 passed by the Court of Learned Session Judge Kasa S. Hilson in Sessions case number 76 of 2023. Also, by the judgments and the order on sentence, comma, the applicant appellant has been sentenced, has been convicted for the offense under section 302 Indian Penal Code, and he has been sentenced to undergo imprisonment for life and to pay a fine of rupees 10,000 in default of payment of fine, to undergo simple imprisonment for another 3 months. Also, we have gone through the statements and amendments made in the instance application, more particularly paragraph 3 thereof. Also, having gone through the statements and amendments, we have the considered view that the applicant have been able to explain the circumstances which caused the delay of 85 days in preparing the accompanying criminal appeal. First, moreover, we are also of the considered view that since the applicant appellant has been sentenced to undergo imprisonment for life, interest of justice will be better observed. If the accompanying criminal appeal is hard on merits after considering the period of delay, Ms. Puyal and traditional the state has barely submitted that the state has no objection if the accompanying criminal appeal is hard on merits after considering the period. Close to. Or in view of the above instance, for the aforesaid reasons, the instant application seeking continuation of delay of so and so days in preparing the connected and accompanying development is allowed para the registry to register the accompanying development and thereafter release the same for admission.
This is the same lordship,
Same,
conviction
okay,
under
45 days.
45 days.
Judgment and order. Dated. 415 click it, BNSS. Order. Okay, judgment dated 12/3/2025 and an order and sentence dated 13/3/2000. Huh? 302 IPC. Imprisonment for life and to pay fine of rupees 10,000 in default of payment of fine. To undergo simple imprisonment for another 3 months. Paragraph. Paragraph 3. Necessary.
Time.
Lordship. Yes.
Yes, madam, more than 1 year. We'll file the opposition. Okay.
The copy has been received by the legal and counsel in the month of
Huh?
June. I have annexed the paragraph 2 of my DA petition.
Where is your document, madam? No explanation,
In paragraph 2, I have explained.
nothing.
I have received a copy on 14/5/25.
Where is your document?
Yes.
You did not annex. Give us some handle.
I have raised my affidavit in the appeal section. In appeal.
Why in the appeal? Item number. Item number 5 vessel. Yes, because there is a letter 14 May 2025. Not because any delay on the part of the applicant. Superintendent, perhaps. Jail authority, perhaps. And there is a nationwide drive also from the Supreme
Yes.
Court. If state objects, it will not be seen in good light. If the court issues notice, it will not be seen in good light. Perhaps. Heard Miss S. Catonian, learned counsel for the applicant appellant, and Miss B. Brian, learned additional public senior counsel and additional public prosecutor, assisted by Miss R. Ras, learned counsel for the opposite party, now opposite party, state of Assam. The instant application under section 5 of the limitation act 1963 is third, seeking condonation of delay of 368 days, which have occurred in filing the accompanying criminal appeal. The applicant, as the appellant, has preferred the accompanying criminal appeal under section 4152, Parotia Nagore Kuraka Honita 2023, against a judgment dated 24/4/2024 and an ordinance sentence dated 26/4/2024 passed by the Court of Learned Sessions Judge Kamrup at Amin in Sessions Case number 228 of 2025. By the judgment and the order on sentence, the applicant appellant has been sentenced to and has been convicted for the offense under section 302 IPC, and he has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 10,000, in default of payment of fine, to undergo rigorous imprisonment for another 6 months. We have gone through the statements and awareness made in the instant application. Though the go in the application, there is not much explanation for the period of delay occurred in between 26/4/2025 and the date of filing the accompanying criminal appeal, Ms. Khatonia Learned Legal Aid Counsel has submitted that that instruction has been received from the Guwahati High Court Legal Services Authority to prefer an appeal by the communication bearing number last communication dated 14/5/2025. After the applicant appellant had sought legal aid. It is submitted by Ms. Katrina and legal counsel that after receipt of the instruction to prefer an appeal, not much the accompanying the memorandum of appeal was prepared with utmost expedition. Therefore, it cannot be, the delay cannot be attributed to the appellant, having regard to the fact that the applicant has been sentenced to undergo imprisonment for life after being convicted under section 302 IPC. We are of the considered view that the interest of justice will be better served if the accompanying criminal appeal is hard on merits, leaving aside the aspect of delay which have occurred in preferring the accompanying criminal appeal. It primarily appears that the delay so caused cannot be attributed solely to the applicant appellant. For proceedings, the delay of 368 days which have occurred in preferring the accompanying criminal appeal is allowed. I'm not according to the registry. New changes will be coming from month.